Can I welcome everyone to this webinar today on just recent cases about Part 36. And today I'm going to look at the construction and validity of Part 36 offers, cases broadly about whether your Part 36 offer made or received is valid, procedural issues relating to Part 36, the consequences of Part 36 offers. And there's no point looking at these number of cases in the abstract. What we can learn from them, that'll be apparent as we go through, and then I'll go back at the end and have a quick resume of the key points. The things to remember from today are that if you want to take notes, remember the PowerPoints will be sent out to you, and they should be available at the moment on a link in Zoom. And also there's a facility to ask questions. I can't read these as we go through, but I have got a session at the end in relation just specifically the questions. And I hope to get to most of the questions that are asked. So the first lesson about Part 36, and this is quite clear from a lot of the cases we're going to be looking at, it can be, if you're not very careful and making a Part 36 offer, a technical minefield. People can and will and are fighting very hard to argue that Part 36 offer is not valid. So if you make the offer, be careful. And if you're dealing with an offer, then you have to check, review the situation and question whether the offer is valid. And the job of making sure that a Part 36 offer is valid on the party making the offer. And that's quite clear from the judgment in Essex County Council. The matter of policy, the responsibility for ensuring that offer is compliant with Part 36 should lie squarely upon the offerer and his lawyers. And there are lots of cases where Part 36 has been offers, or ostensible Part 36 offers have been held to be invalid, or the claimants needed relief. Sometimes the maker of the Part 36 offer needed relief. To make it to be valid. And the first one is Flanagan and the Royal Sun Alliance, and the offer made was this: the offer is open for acceptance for 21 days. The date this letter is received by you. After 21 days, the offer can only be accepted if you're able to reach agreement on cost or the court gives permission. Now, what the district judge said, construing that, was that the offer was actually withdrawn after 21 days, if you read it, and therefore there is no offer on the paragraph on the Part 36 because the offer lapsed after 21 days. Also, because as I said, because the defendant or the claimant making the offer attempted to vary the cost consequences after the 21 days, it means it wasn't a Part 36 offer. So first of all, it was badly worded, and second, and wasn't valid for that reason. And secondly, it was invalid because there's an attempt to vary the normal cost consequences if a party accepted a Part 36 offer. Another case where a claimant or an offerer fell to grief was James and James. That letter offered to settle on terms which included a term the claimant was liable to pay the defendant's cost of the claim and the counterclaim up to the date of relevant period or later, or if later, the date of service or notice of acceptance of the offer. And again, the clumsy wording used meant that the offer made wasn't an offer within CPR 36. It doesn't make grammatical sense, and it's absurd. And the problem that the writer is putting forward terms on which costs to be paid which are inconsistent with the rule, and it's not an offer with CPR 36, and therefore doesn't carry Part 36 consequences. And another, give you an idea of the kind of arguments that can be raised in relation to the validity of Part 36 offers, is the Essex County Council case. The claimant sent an offer by email. I know he's got on the 7th of March. It was sent after 4:30. They're deemed to arrive the following day. And the defendant argued it was not a valid offer because the offer was dated the 7th of March, said to run for 21 days from this date. But you can see the force in that. It was deemed to arrive a day later. It's not an effective offer. Didn't find favour with the judge, though. I prefer the latter construction consistent with the clear intention to make a Part 36 offer and choose the offer is effective. I reject the UBB's argument. The offer letter was not compliant with Part 36, but it just shows how careful you've got to be. And if you are not using the form, the first and most important lesson I think you should derive from these series of cases is that there are real dangers in not using the form when you're making a Part 36 offer. And you're going off piste. You might think you're paraphrasing the wording of Part 36. You may think you're getting it right, but people will use arguments if there's even one word different. The form itself would avoid that problem, because if the offer is accepted within so many days, 21 days obviously, of service of this notice. So there are major advantages in using the form, and be very, very careful if you're not. Now, if you're not using the form because you want to get some cost advantage or some kind of variation on the normal consequences of not using a Part 36, you're in danger again, because we've already seen the courts are saying you can't do that. The rules are set, and if you try to get any kind of different order for costs, it's not going to be a valid Part 36 offer anyway. The other arguments relating to the validity of a Part 36 offer about dates. We see this in King Security. There's a claimant recovers 40,000, made an offer of 30,000. The terms of the offer were this: it's intended to be a claims Part 36 offer. If your client accepts this offer within 21 days, your client will allow for our costs. The offer will remain open. And the argument was from the defendant that this wasn't a valid offer was the reasonable recipient of the letter, knowing that the intention was to send a Part 36 offer, would have realised that the reference to 19th July was mistaken, and it was intended to refer to a 21-day period ending on the 22nd of July. The additional words or any time thereafter did not deprive the Part 36 of its intending effect. And the judge said he may have been able to, or may have considered issues of estoppel, but it wasn't necessary. It shouldn't be introduced in the operation of the Part 36 regime. But that's another case. Well, that's very, very important. And the consequences of the Part 36 offer, and it being a valid Part 36 offer, were major, because in that case, the claimants has spent £2 million in costs in obtaining a judgment of £40,000. So all those parts of the assessment where proportionality didn't have to be considered were going to be very, very important, because cost on the indemnity basis means you don't have to consider proportionality, and it could make a major outcome in relation to the cost that the claimant was going to recover. And we'll talk about the consequences and the cost consequences and the advantages of Part 36 offers a bit later on when we look at the cases on those subjects. And another example of the lengths that people will go to argue that a Part 36 is not valid is the Trucadero case. And basically, it's a classic, if you like, COVID issue. The claim in relation to unpaid rent. The cinema isn't getting any money in because no one could go to the cinema. And the claimant made a Part 36 offer, the claimant landlord, which was marginally low. They were rent they were going to recover, which was clever, really, because it was an all or nothing case in some ways. They could only recover. They were always going to get if they're going to get anything, they were going to get the rent they were claiming. But they obviously beat their own Part 36 offer. And the point the defendant took was that I didn't agree to service by email. You're not being properly served, it's by email, and defendant solicitor has not stated the way to accept service by email. And what the claimant said, what the claimant had to do was rely on CPR 3.10, that it was a breach that really had no material effect, and the court said it would be a triumph of form over substance if the court will make an order invalidating the Part 36 offer. So you might think, well, what's the point of taking that kind of issue? Well, we're going to come back to this later, this case, because it actually did have consequences when the court was considering the likely what orders should be made as a result of the claimant beating his own Part 36 offer. And the other important procedural case in relation to Part 36 offers mistakes is the O'Grady case. It's a fatal accident case. There's an argument about apportionment, contribution negligence, and the claimant solicitors send a letter saying we will concede contribution negligence of 80% when they meant 20%, and the defendant accepted. And they said, that's it now. You know, Part 36 is a self-contained code. There's no room for the doctrine of mistake. You're caught by your own offer of 80% contribution negligence. And that argument was not accepted by the court. And it was held quite clearly the doctrine of common law mistake can apply to a Part 36 offer in circumstances where a clear and obvious mistake has been made, and this is appreciated by the Part 36 offeree at the point of acceptance. And what was interesting there, I actually spoke to the claimant's counsel in that case, and it got to the stage where they'd issued an application for the defendant solicitor to attend court to give evidence on the basis that when it was received, it was a clear and obvious mistake. And eventually that was conceded as a point. It wasn't an issue, and the defendant solicitor didn't give evidence. But it's not every mistake that you can get over on this. For instance, if they'd meant to say 20% but put 30%, that may not have been a clear and obvious mistake, and they would have been caught by that. So there is, if you like, some relief here. But remember, it has to be a clear and obvious mistake and appreciated by the person getting the offer. And the other interesting case in relation to construction of Part 36 offers is the Huntsworth Wine Company Limited. Now, in there, the defendant in an action in which they brought a counterclaim had prior to the action made a Part 36 offer. Basically, the claimant stores wine in the defendant's warehouses. The wine gets stolen. The claimant sues for the cost of the stolen wine, and the defendant relies on a clause that says we are liable for a small amount of money only. That's what we've got to pay you. And in fact, there's a balance due to us. Prior to the claimant issue proceedings, the defendant sent a Part 36 offer saying we will accept £2,000 relating to potential proceedings brought by the claimant, by the warehouse owner. In fact, the warehouse owner doesn't issue separate proceedings. It brings its action as a counterclaim in the action brought by the wine company. And the form of the offer is this. It's the claimant's Part 36 offer, and it settles the whole of the claim. So when the matter got to trial, the defendant, the warehouse owner, succeeded in showing that it was only liable to a certain extent, and it beat its own Part 36 offer. The question was, can a defendant in a case make an offer that is a claimant's Part 36 offer and gets the consequences? Because the claimant's Part 36 offer in those circumstances are much better because of the indemnity costs. And the judge held that this could be viewed as a claimant's Part 36 offer. First of all, not important who made the first offer. You can't construe Part 36 on the basis, the person who made the first offer is definitely the key person. Secondly, it didn't not matter that the offer was made in fictional proceedings because it referred to a county court proceedings that never brought. And so the defendant had won and was entitled to the benefits of a claimant's Part 36 offer, and that includes extra interest, not the extra percentage damages, and more importantly, I suspect in that particular case, the indemnity costs. The other important case, Court of Appeal decision, Seabrook and Adam, it's about the construction of Part 36 offers and when is a Part 36 offer on liability valid when causation and damages are in dispute. The claimant's involved in a car accident, causation issues are in dispute. The claimant made an offer to accept 90% on liability. And there were basically two injuries. There was the neck and the back. And the claimant succeeded at trial in arguing there was a finding that there was a neck injury, not on that there was a back injury. But prior to the trial, it made an offer of not to accept 90% of the damages. The claimant's argument was, well, if you'd accepted my 90% offer, you would have only had to pay 90% of the damages that were assessed. And the reason the claimant didn't succeed in that, and I argued this at the Court of Appeal stage, and in fact before the circuit judge as well. The reason it didn't succeed because the Court of Appeal held that if the claimant had accepted, if the claimant defendant had accepted the claimant's offer, they were bound to accept issues of causation. So the accepting defendant would have had to, if they'd accepted 90%, would have been deemed to accept that there was a back injury as well. Well, that's important to any defendant thinking of accepting an offer, because it seems to say that if you accept an offer on liability, you're accepting, to what extent is not clear, but you're accepting the claimant's case on causation. And as a result of that, and the lack of, well, as a result of that, it wasn't an effective Part 36 offer. What the Court of Appeal said, cases of this time turn on the precise wording of the pleadings, and in order to avoid this kind of dispute, the claimant's offer has to be very, very precise. And in relation to liability, it was sensible to make clear whether the defendant has been invited to only to admit a breach of duty, or the admission is admitted to go further on what damage the defendant has been invited to accept was caused by that breach of duty. So you can still do it, but if you want to make it clear the defendant can still argue issues of causation, then you should make that clear in the offer. Moving on. What happens if an offer is made less than 21 days before the date set for trial? And in this case, it's particularly interesting because the trial was adjourned after the offer was made, and was the offer effective? And the judge held, and it was upheld, that an offer made 21 days before the date set for trial was not an effective offer. Unless a period of less than 21 days is stipulated, because you want that kind of certainty. And what the Court of Appeal said was that parties should have as little uncertainty as possible when they're considering whether Part 36 offers are made. If the party made the offer wants the offer to be effective, you've got to apply to abridge the relevant time period. And there was an argument. We think we did that. But there's no record of it, no note, nothing in the appeal papers. And in any event, the Court of Appeal says, or the appeal court says, it wouldn't have been appropriate for the judge to abridge time retrospective in those circumstances. So it wasn't, in those circumstances, a valid Part 36 offer. It was a hard offer, offered little incentive to the third party, and wasn't accepted. Another issue on the Part 36 is whether or not a defendant can argue something slightly different when he makes an offer and it's accepted, and quite probably unusual circumstances in the case of Denton here, a new Denton case. The insurer sued under the third party. The insurer was sued, under the Third Parties Writing Insurers Act. Remember, in those circumstances, when you're suing under the Act, the claimant stands in the shoes of the insured. And the offer made of $8,250, and the claimant accepts it. And the defendant said, well, the insurer, there's a $1,000 deductible you've got to take away from the $8,250. And the claimant went to judgment when they weren't paid, and the insurer applied to set aside the judgment. And the court held the defendant was not successful. The Part 36 offer was unambiguous and clear. The insurer was defended the claim. If the insurer wanted to set the claim for a sum that took into account the deductible, it should have done, though. The insurer chose to use Part 36. And the claim having accepted the Part 36 offer was quite entitled to enter judgment, and the application to have the judgment set aside was dismissed. So it shows there all the insurer needed to do is saying, here's an offer of 7,250. We've taken into account the £1,000 deduction, and the insurer would have made a valid offer. And also in a case like that, it's not a case where they can say it's a mistake, because remember, it has to be a clear and obvious mistake. And at 8,250, without the deduction, probably wasn't a clear and obvious mistake in the eyes of the recipient of the offer. And I want to go and look at other procedural issues around Part 36. I think interesting case of Wormald and Ahmed, and it's the problem when a claimant was seriously injured. The defendant made a Part 36 offer. Sometime later, the claimant dies, and as a result, because the way fatal accident damages work, the claim worth far less, because we haven't got those years and years of claims for care. So the claimant then, the estate then said, we'll accept their offer now, and the claimant was under a disability. And what the court held was there was no compromise, no valid offer until the Part 36 offer was approved, or the offer made was approved by the court. Either party can apply for approval of the settlement, but the fact is, in any event, the defendant would have allowed the court would have allowed the defendant to withdraw the offer. It would have been unjust to allow the Part 36 offer to continue. So the first point there is, A, that you need the court's permission for a valid kind of Part 36 offer to be accepted. You need the court's permission, and B, on the facts of that case, the court would have allowed the party to withdraw the offer. And the other point in relation to the construction of Part 36 offers is that you can't put a caveat on acceptance of an offer. Now, I've already looked at those cases where the claimants tried, or the personal party making the offer, has tried to put a caveat on costs or kind of get a different result when they're making the offer. That invalidates the offer. And in the case of Jimenez, defendant made an offer of 5,300. The claimant accepted and tried to accept with a caveat. We assume from the terms of the offer that our client's costs will be dealt with on a post-issue fixed cost basis, and they said this is on the basis our client's post-issue fixed costs and reasonable disbursements. But the court said you can't put a caveat on acceptance. There is no provision within Part 36 for unilateral conditions or qualifications to be attached to offers, and therefore the costs that the claimant were seeking were not recoverable. The claimant's costs were reduced from 8,000 to 1,000, sorry, 8,100 to 1,706, and the claimant was ordered to pay the defendant's cost of the assessment proceedings at 2,408. So you can see there, as a result of this argument, the claimant's out of pocket by a good £800 thereabouts. Arguing about costs has led to the claimant recovering absolutely nothing. So there, if you look in over the past kind of 12 to 18 months or so, are the kind of major procedural matters relating to the construction of Part 36 offers. And I want to look at the consequence of Part 36 offers. And one case makes clear that Part 36 offers are meant to be harsh. And we've got the case of Shah and Shah, very protracted family dispute. And the claimant made an offer to settle for £1. Remember, these are disputes that are where the costs have run tens of hundreds of thousands of pounds. The claimant got judgment for £10, essentially nominal damages, but still, a lot more than the offer they'd made. And the judge found that the offer had its usual consequences. And costs up to the date of Part 36 offer and Part 36 consequences thereafter, including indemnity costs, remember, the proportionality goes out of the window. defendant appealed, and the fact that it was punishing didn't mean it was unjust. The judge found that it was a punishing result of the not accepting the Part 36 offer, but that doesn't mean it's unjust. The justice of Part 36 is that decisions about litigation should be economically utilitarian. It actively discourages litigations on point of principle by making litigation not fought on a commercial basis a high stakes activity. So remember that a Part 36 offer of £1 leads to indemnity costs and all the other Part 36 benefits. One case where there was a variation in the usual consequences with Culver and Head and Culver, and that case is very unusual in a lot of ways. But fatal accident lost years case where the claimant's claiming for reduced inability to or loss of income in the lost years. And the claimant didn't succeed in part of his argument at trial, but won in the Court of Appeal, where the Court of Appeal said, yeah, what you should do here in relation to the business in question is show how the claimant's income would have tapered down or changed over the years in question. So as a result of that appeal decision, the claimant put in new evidence to show how his income would have tapered over the years since over the years prior to his accelerated death and afterwards. And because that postdates the Part 36 offer that it made. And what the court held there, it was this new evidence, which reflected the test the Court of Appeal said apply, was important, and the court wouldn't have been able to award damages without that new evidence, and it would be unjust. It would be unjust on the facts of those case for the normal Part 36 offers to apply, and as a result, it was held it didn't apply. And another personal injury case is the case of Algamal. It's a personal injury action. Every element of the action seems to be fought, including the defendant saying that the claimant was fundamentally dishonest, and the trial judge rejected the allegations of fundamental dishonesty. The defendant appealed against that finding of an absence of fundamental dishonesty, and that was refused. And they also said we shouldn't have had to face the normal Part 36 consequences because the claimant beat their offer. And the court said an appeal. There is nothing wrong with the judge's approach or decision. There's a discretion decision for the judge to make, taking into account all the circumstances of the case. The judge decided to apply the usual cost consequences. He did not consider it unjust to do so, and I can fully understand his decision, which was well within the ambit of his discretion. After all, the claimant had made a reasonable Part 36 offer, had established his case at trial, and had defeated the fundamental dishonesty argument. I see no basis for overturning the judge's decision. And there's some very interesting arguments in relation to the consequences of Part 36 in the case of Equitix v. Bimax. Basically, the claimant obtained judgment for £11 million, and the counterclaim was dismissed, and then the claimant had beaten its own Part 36 offer. So the defendant was faced with the Part 36 consequences of more interest, obviously indemnity costs, and it was a case where the additional interest was going to be very substantial. And what they said, and I think it was very brave what they said to run it, was that because there'd been an offer for the claimant to accept 5.4 million, the accelerated interest or the additional interest should only be on that figure that the claimant had said it would accept, not the £11 million that the claimant received. Well, that didn't. First of all, an argument that the defendant's first argument didn't run. The argument that they couldn't. Sorry, the defendant's first argument was they couldn't calculate the risk involved, until a later time. They wanted the costs to run from that time, the consequences, and that was rejected because much of the purpose of Part 36 would be lost, the cost of which the regime was intended to prevent being incurred. A well-judged Part 36 offer is often based on inspired and educated guesswork, whichever party must also display when deciding to accept it. So the argument it should be from a later date when we could actually assess the offer was rejected. And the argument I've just outlined about information interest, the enhanced rates of interest, it's going to be payable on the sum the claimant recovered, not the sum the claimant offered. And the third lesson I want you to take away is a well-judged Part 36 offer is often based on inspired and educated guesswork, which the other party must also display when deciding whether to accept it. So it's the litigator's dilemma, if you like. Someone makes an offer and you don't know, you haven't got all the information you need, whether to accept it. You've got to be involved then in inspired and educated guesswork with your client. You've got to say these are the risks, these are the advantages. Often, the defendant will make an offer without finding a counter schedule, and so you've got to kind of look at your own case and analyse it. The courts aren't very sympathetic or sympathetic at all to cases which say, oh, well, I didn't know how much it was worth. I had to have a bit more time, a bit more information. That's rarely, if ever, going to deprive a party of the normal Part 36 consequences. There is a case where it was held to be unjust for the normal consequences to be applied, and that's the case of Trucadero, which we looked at earlier on, the cinema case, where the landlord was suing for its rent, which the cinema didn't want to pay because it had no income. The claim for rent with a very small concession. First of all, there was an argument, well, you only knocked a percentage off rent you were bound to recover, and therefore this was not a genuine offer. Yes, it was. The fact the offer was made on the eve of the third lockdown, and there were other landlords and tenants agreeing concessions, it didn't mean it was not a genuine offer. Therefore, I reject the argument that Part 36 offer was not a genuine offer to settle. I do need, however, to go on to consider whether it would be unjust. And in the facts of this case, the judge found it was unjust for some, not all, but some of the Part 36 consequences to apply. First of all, COVID. Because we have a case where the cinema wasn't getting customers in, couldn't pay its rent for that reason, it would be unjust to, for the full rigor, not all of it, to apply. Events after the offer were taken into account, and significantly important was remember earlier on we had the issue of, well, this was an offer made by email and not by post, and therefore the claimant had to run CPR 3.10, and the judge said it was a relevant factor to take into account the defective service of the Part 36 offer. Although I've concluded that I can exercise my use CPR 3.10, it's another reason. The fact the Part 36 offer is not being voluntarily made is a reason why it would be unjust to award the claimant the maximum. And so the judge found it be unjust to order the defendant to pay an additional amount. And the reason for that is the introduction of the Part 36 offer, and there was an introduction after the event, but of an arbitration scheme where landlords and tenants in these circumstances were trying to sort matters out. There was also no enhanced interest, but interest at the judgment rate, and but indemnity costs were awarded. So, turning to the question of cost, I'm satisfied with the right for the claimant to receive its costs in relation to the matters dealt with in the summary judgment. I think that this is the second time we've had the third lesson. I think the second and third lesson have got combined. We're a lot of arguments now in relation to Part 36 and why it's important in relation to claimant's offers are because of that indemnity cost issue. That relatively small amounts of money can be in dispute, lots of cost incurred, and if we get rid of that principle of proportionality, as indemnity costs do, it can be important. The other point is, and the Part 36 offers can apply to cost, and there are examples of this working. Master was assessing costs where the defendant Secretary of State was liable to pay the claimant. Claimant made a Part 36 offer on costs which the defendant failed to beat, and the defendant said it would be unjust for us to pay the additional sum on costs, increasing the other £7,000. And the argument were the public purse. It's public money, and it's coming from the public purse. And this argument found no sympathy at all with the High Court Master. Because A, the Secretary of State could have mitigated its loss. He could have paid a substantial sum on amount and decreased the interest. B, the government, the state, local authorities, any emanation of the state is not a special category of litigant. I'm aware of any authority which binds the court that it would be just to order payment of the additional sum where the public purse is paying, as opposed to the situation where it's an individual. And the Master was fairly unimpressed with the conduct of the defendant, because the defendant could have mitigated its liability by making a payment on account. No obligation to do so, did so late. And so let's think about that. Paying parties in an assessment, you can mitigate your liability for interest, which runs at 8%, and arguably higher if the claimant makes a Part 36 offer. It just makes commercial sense, irrespective of any delay, by receiving parties serving their bill. And then the Master goes on, doesn't stop there. The public purse, there was an argument raised about the public purse, which the Master found I think depressing is the word used somewhere. Having carried out numerous provision and detailed assessments, it is dispiriting, that's the word, how much public money is expended unnecessarily in arguing about these costs of assessment. Many such matters will have been capable of a settlement much earlier, either through effective Part 36 offers being made in an early stage, or through a cost mediation before the fee for the assessment has been incurred. And it goes on in relation to the public purse. The public purse was put to unnecessary expense by the defendant's failure to make a Part 36 offer at a level sufficient to give it cost protection, had it been rejected, and a sufficient sum to be attractive to the claimant to make it acceptable. Not only that, but here the defendant's shortcomings were compounded by the fact that a realistic Part 36 offer was turned down, comprising, as it turned out, interest to date, as well as the amount which the claimant was willing to accept for his costs. So it is a pity, therefore, in this case, advancing the public purse argument, the defendant appears to have overlooked the guidance given by Peter Smith, in a position where one party is liable to pay the other's costs, which provides for Part 36 to apply in detailed assessment proceedings. The rules now apply for Part 36 to apply in detailed assessment proceedings. And this is an important point about Part 36 and costs generally. This appeal emphasizes the need for paying parties who wish to protect themselves against the costs to make an early offer and an early and realistic settlement, both sides. Can we see an example of a practical difference on a Part 36 in relation to costs? We'll go back to the Huntsworth Wine Company case. Remember, that was the case in which the wine company was suing the warehouse because the wine had got stolen. And we can see here there's a issue about the indemnity cost giving right to a different test. In an earlier hearing, the judges were concerned about the running up of costs. But I, says the judge, who's assessing costs at the end of the trial, because it's the shorter trial scheme, I'm assessing cost on an indemnity basis. And it's a different test, a no proportionality and resolution of any doubt being favourable to the receiving party. Had the assessment of these costs been subject to the test of proportionality, I would have unquestionably have considered the figure to be disproportionate. So it's very, very important to get your Part 36 offers in early in relation to that kind of issue. Particularly in the kind of mid-level if you like, disputes or amounts of money where the difference between indemnity costs and costs on a standard basis can be quite substantial. Can we deal then with the other issue of Part 36 costs and appeal? Remember, you can make Part 36 costs and appeal, and we're looking at Swift and Carpenter. Anyone doing personal injury litigation will be aware Swift and Carpenter was a case about how the court should assess accommodation costs in the current climate, to the problems with multipliers, and it found out a new way of doing it. So the point about Smith and Carpenter that I want to bring home is that the Part 36 applies to appeals. As a result of making a Part 36 offer, the claimant received an uplift on damages of £69,000, indemnity costs following the Part 36 offer, and an additional amount of interest assessed at 4.5%. So even on an appeal, you can make a Part 36 offer, and you can see there we get the claimant getting another £69,000. So the fifth lesson, there are dangers in not making a Part 36 offer at all. This can be seen in the case of Global Energy Horizons. And what we have there was the claimant brought an action, was claiming £227 million. He received £3.6 million at trial. And the judge said, you've only got a fraction of what you're claiming. I'm not going to make any awards for costs at trial. The defendant never made a Part 36 offer. And that decision to make no order for costs was overturned by the Court of Appeal. And what they say in clear terms is that where a defendant is faced with an exorbitant claim which he wishes to defend vigorously, but where he's vulnerable to a finding he's liable for a much smaller amount, there's a clear process provided by CPR Part 36 which can protect their position. So it is difficult when you've got a large, ridiculous claim. You can just say, let's fight it out, hope to show it's so ridiculous that we don't get an order for costs. But there's clear guidance now, the Court of Appeal, that is a dangerous step. You'd probably be far better advised to make the Part 36 offer at a realistic level, and then argue issues of proportionality and costs later on, because you can say, look, they were claiming tens of millions, they've only got, and they only got 3 million, therefore costs are disproportional. That's still be argued on assessment, although you're still going to be liable because for the costs that are assessed. So what can we learn from this? First of all, arguments about the construction of Part 36 offer are still rife, and they're not going to end because the consequences are so large for both sides. If you make an offer as a claim to a defendant, make sure your offer complies with the rules and there's a valid Part 36 offer. We've been seeing even slight variations make it an invalid Part 36 offer and create problems. And make sure it's served, because as we've seen, unless the actual recipient says we accept service by email, it's not enough. Seems ridiculous in this day and age, but that was a finding, I think, from earlier this year, certainly in the past 12 months. And the other point is you cannot put a caveat on a Part 36 offer or acceptance. You cannot say we're not going to pay your costs, for instance, if you make a Part 36 offer, it won't be a valid Part 36 offer, and a defendant can't put a caveat in relation to acceptance. The other point is that the consequences of Part 36 are meant to be harsh. It's a policy matter. Escapes from this are rare, but don't be encouraged by those, because it's possible, but rare. And the other point I want to take away is that Part 36 offers can be made effectively in several aspects of litigation. On the main issue, on liability, we've seen the problem I had with Seabrook in the Court of Appeal, but it's still possible to do. On damages, on costs, and on appeal. And the 3 points I want to end, but we've got a lot of questions I can see, so I think about 30 odd questions. So, but the 3 points I want to make before I end, first of all, the duty's on you. And remember that quote, the responsibility for ensuring that offers comply with Part 36 should be laid squarely upon the offerer and his lawyers. And I'll repeat the point, there's a nice handy form that you can use, And there are dangers if you just draft the letter and it even changes the part physics offer by a few words. Secondly, it does, I'm afraid, both offers and looking at offers require inspired and educated guesswork, which the other party must also display when deciding whether to accept it. And then the third point I want to make is that there are major offers or major dangers, in not making an offer at all. And the Court of Appeal decision that if you're faced with an exorbitant claim, there's a clear process under Part 36 where you can protect your position. So I'm going to get to the questions soon, and they keep, I can see on the chat function they're going up. But first of all, I'm going to do the adversarial point. It's the price you have to pay for watching this afternoon. Remind you that this is brought to you by the Cost of Litigation Funding team at King's, and show you the picture of Harry there, our senior clerk, and then Vase, who, although I think he looks about 12 in that photo, he's a very able and experienced clerk. Give you the quick blurb in relation to the team as a whole. The only regional separate chambers and partners since 2016. There's a whole batch of them, and I'll spare you the photographs of my fellow members of the team. Some of them are photogenic, some of us aren't. I know which category I fall in. And I will just now look at the questions that have come up. I'm looking at the chat function first, and then I'll look at the Q&A. Okay. Right now, I can't see. Yeah, the link's up on the Q&A, and that's fine. There's a lot of people saying very useful. And I'll now look at the Q&A section. This is a question from Jonathan White. Does the Part 36 doctrine mistake provide any assistance in cases where errors are made on cases in the claims portal? I don't think it does, because those errors in the portal cases were considered in that case, Jonathan, and they said no, Part 36 is different to the portal. I think it can be looked at next time it comes up, but I don't think it gives you a direct precedent. You can argue in relation to, well, you should deal with errors on the portal differently. And here's an interesting question from Mark. Following the wine merchant case, as I understand it, the current claimant's offer was made pre-issue. Are the same principles like to apply if a defendant makes a claim as Part 36 of post-issue, referring to the individual claim as a counterclaim with the wording? I think they are, Mark. You have a close read of the judgment, and it says it doesn't matter who made the offer first, and that a counterclaiming defendant's offer made in those circumstances is going to be treated as a claimant's offer. Now, I'm going to have to read this question. How do I see this affecting claims that are started out in life, but maybe dropped for complexity or fundamental dishonesty? If the amount still remains under 5,000, meaning it would still be part of the small claims track, if a Part 36 is then made, what would the cost consequences be? And can I come back to you on that? Get my direct email address if you need. I think that issue, this is a specific issue about costs in the new small claims regime for road traffic accidents, and there is a specific regime there, and it's a bit too specific, if you like, for me to deal with a general webinar. I'm not ducking that. It's an interesting issue, and one of the great things about questions like this, I do enjoy them because it gives me ideas for later webinars. Oh yes, here's a very interesting question from Laura. What is the position on Part 36 on non-money claims? Any claims through a declaration by the Court of Injunctions? Would this practically be done? Is there any way to protect the position on costs in these circumstances? Yeah, well, first of all, remember that Part 36 for £1 was effective, and that was all largely about declarations. But yes, I think you can make a Part 36 offer on non-money claims. You've got to say we will accept A, B, C, D, E, and then see if you do any better at trial, basically. And it can be quite difficult in relation to non-monetary issues, to whether or not the claimant or the claimant's done better or not than the offer you're making. But certainly you can employ it in the same way and say, this is a Part 36, this is what we accept. You don't need better. We want the cost consequences. When making a defendant's offer pre-action, should you offer costs? There are any suggestions you could, even though there is no pre-action cost regime? Well, I think that's a good question from Christine. And the answer is yes, because if you want it to be a Part 36 offer, you can't put a restriction on costs. So remember, if it's a Part 36 offer, you're offering to pay the costs. And if you say we're not going to pay the costs, then it's not a Part 36 offer. It's an offer, but it won't be a valid Part 36 offer. So basically, you've got to, and there are dangers in restricting it. Okay. Is it sufficient for an offer from one solicitor to simply say in an offer letter the usual Part 36 consequences will apply? I don't think it does. I think, Keith, your answer to that question, it's a good question, but I think that's why I'm saying to you, use the form. Use the form, because what the usual Part 36 consequences apply? What happens if one party becomes a litigant in person? How are they supposed to understand it? You've really got to spell it out to be a valid Part 36 offer. We've looked at cases where changing terms or changing a few words means it's not a valid Part 36 offer. I think you'd be struggling if it was really put to the test to say the usual Part 36 consequences apply is a valid Part 36 offer. Does the inspired guess betray a failure to appreciate the difficulty the defendant faces where a claimant has failed to give adequate disclosure? There must be a line, of course, but should litigation be guesswork? David, that's a much larger question than just Part 36. I appreciate what you're saying, but yes, basically, the Part 36 offer is an inspired guess, and you can always review it later on if it's wrong, if it's not accepted. But yes, I agree, litigation shouldn't be guesswork. The pre-action protocols should actually give you the information you need, in theory, to get all the information you need to make an offer. And I appreciate that in theory is a big in theory. And then there is there's a bigger issue there, David. But I think it is a good point. RE service by mail, I thought authority referred to earlier said it was acceptable. No, what that case says we looked at was that an offer has to be served by a method allowed by the receiving party. If the receiving party said we don't accept service of documents by email, it's not valid service. Now it's fairly early overturned by CPR 3.10. So, but the authority earlier said it was acceptable. It was acceptable because 3.10 was used by the court to say it was a valid offer. But then that fact that 3.10 had to be used was used by the judge at the later stage about what penalties should apply to say that one of the reasons I'm not going to apply all the normal Part 36 penalties is that I had to use 3.10. N424 is a cash offer covering email contains offer of fixed costs. Can the N40A be accepted over time so the cost can be decided by the court? Well, the use of the form means that the party making the offer is agreeing to pay the costs. They can't put a caveat on costs. I'm not sure, Anthony, I quite understand the question. It may well be me. If you can clarify that, because there may be a fixed cost apply, then obviously you're accepting them, but if you accept the offer, they can't put a proviso on the cost. There's nothing to prevent you arguing about them. But there are cases, and we've looked at them, where they're arguing about the costs, or the cost of argument, the cost being more than the cost themselves, and the claimant's been out of pocket. What are your views on enforcing a Part 36 offer where the defendants do not pay damages on time? Well, there's a clear procedure in Part 36, was that you enter judgment and enforce it just like any other judgment. And in fact, that's what had happened in the case we looked at about the indemnity insurers who weren't paying up. The claimant just went into judgment. Part 36 Health has an internal procedure that allows you to do that. And then there's a note here, Part 36 does not apply to small claims. That's absolutely right. I've received a Part 36 of an RTA. Could I reject to provide a counteroffer, or should I make a counteroffer but not reject the initial offer made within the Part 36 offer which was made in a written explanation? Right. Well, that's you're asking me to advise on a specific case. I'm going to give a general advice. because Part 36 is its own code, then a counteroffer doesn't mean a rejection. But that's asking me for a very, very specific advice in relation to a specific case. But basically, a counteroffer doesn't involve a rejection under the Part 36 regime. And I think that's as far as I can take it. That's an interesting question, Jamie. Is it still the court's position that Part 36 offers cannot be made when Solicitors Act proceedings raised in solicitors' own client assessments? I don't know the answer to that, Jamie, to be honest. I can't think it's excluded, but I will just make a note of that. Court and sole own assessments, Part 36 offer. And I'll get back to you on that, Jamie. Just watch my blog, all I can say. If a claim is perceived to be a trial, and so they will accept £1 plus costs, is a Part 36 offer still worth the risk? Again, it's all fact specific, isn't it? The party who made that offer of £1 plus cost benefited greatly from it. So I'm not quite sure what the purpose of that question is. And again, another question I don't understand here. Can a singular Part 36 offer being made by one of the defendants be accepted simultaneously with a joint Part 36 and made on behalf of two defendants? I don't quite understand the question. I'm sorry, it may be the way it's phrased. What is the best way to make an offer on damages and costs? I accept lower costs than would have been underworded under the CPR. But you can't do it on the Part 36. That's all I can say there. Because if you're trying to put a caveat on costs, you can, it's not a Part 36 offer. What you could do is make a Part 36 offer on damages, separate one on costs if you want to accept lower costs. Then there are two different Part 36 offers to be made there. How do we square a mistake with Part 36 not being a contraction scheme? Well, Raleigh, I've told you what the case is. The judge had no problem accepting it. I doubt if there will be an appeal. I'll let you know if there is, but that's where it is. He told the doctrine of mistake does apply to Part 36. Is it valid to make a global offer for damages and costs? Well, it's an offer, but it's not a Part 36 offer, Douglas. It's an offer. It's just a, if you like, a callback offer or similar. You can make two offers, one for damages and one for costs, and the claimant could, if accepted one, may not accept the other. But an offer which includes a global offer for damages and costs is not and can never be a valid Part 36 offer. Do parties have to give a breakdown an offer of damage to claim for numerous heads of loss? No, they don't have to. You can ask them to clarify the terms of an offer, but we come back to our inspired guesswork. Basically, you've got to take your own view. Will Part 36 survive if the defendant company goes into administration? Yes, is the blunt answer. I'm not sure who's made the offer though. I can't see why it would go invalid in this situation. There's a question here: how does inspired, educated guesswork sit with CPR 36.8? I don't know. I don't know if that's a. I'll come back to that. So, what is your view on the ability of a Part 36 offer being served by direct access barrister? Will this be valuable potentially exercising litigation powers they don't have? I don't know the answer to that. It's a question about direct access rules, and I think the best people to ask are the Bar Council, not me. I don't have a direct access license, and I think even if it's not valid, if it's outside the terms of their litigation powers, there's always the possibility the court could exercise its discretion on the CPR 3.10. There's a question here about maritime arbitration, and says the tribunal does not have to take account of sealed Part 36 offers. Are these latest precedents enough to press for the sealed Part 36 offers present by the tribunal in any given arbitration? I think that's a massive question that I can't even begin to answer. You're asking me about the maritime arbitration things. These are Part 36 offers, the form that used in Part 36 in the civil procedure rules. Whether or not they apply in maritime arbitration I couldn't begin to advise you. There's a question here: where a claim settles in excess of £25,000, and the party making the offer adds a caveat they're only paying MOG portal costs, letter with no form, would the party the offer be bound to accept those costs? No. If it's a Part 36 offer, they can't put a caveat on the costs, and it won't be a valid Part 36 offer. The court will assess the cost. It's not a thing I can advise you on without seeing the actual offer. Richard Drinkwater, does Part 36 need amending? That's an interesting question, Richard. There's two schools of thought. There's so many cases about it, and I can bet you almost hard cash I'll be back here. I could be here next year, make this an annual event, this year's cases on Part 36. There's a school of thought that says yes, because there's so many cases about it. The school of thought that says the reason there are so many cases about it is because people are using it, and we're arguing about the matters on the periphery. If they amend it, there'll be another dozen cases about the amendments. So I think it probably needs tinkering with. I don't remember this kind of cases from the old days of payments in the court, but it's being used. That's what we can say. Does the form provide for sunset clauses? Does the form provide for the ability to prescribe interest to run if accepted late? No, the form doesn't, and neither do the rules. If you try to get those in, then it's not a valid Part 36 offer. I understand there was a recent order which suggests that cost implications apply if an order was made. The name eludes me. Is this correct, and what the issues, the consequences? I think, Nicole, that might be the case about the claimant's Part 36 offers. They're often accepted late. The claimant makes a Part 36 offer, and then the defendant accepts it 2 years later, and the consequences don't apply automatically. All kinds of grounds about it. There has to be a court order, and the name eludes me as well, but it's basically there. The offer's there. The defendant can accept it late without consequences if you're making a claimant offer. Different for a defendant, because the cost consequences kick in from the 21 days after the offer is made. Right, there's a question here about the costs. Where an intransigent party is successful, the £227 million, it's 3 million, and guess its cost on the Part 36. Does it appear the court take account of the cost of paying party in dealing with the elements affected by the intransigence? Can assessment of the receiving party's costs address this? Yeah, that's David. That's a question about costs, and the case we're talking about, where there was £3 million and awarded, and a huge claim, no one would have made a Part 36 offer. Okay, so if, for instance, the claimant had made an offer of 3 million, say £2.5 million, and got 3 million, even though it was claiming 227, the consequences for the claimant would be huge, because a large part of the costs would be assessed on the indemnity basis, and there's no issue of proportionality, and then doubt is resolved in favour of the receiving party. Now, there's a wider issue, was that if I've claimed £227 million and I get 3 million, well, of course, there's going to be loads and loads of issues on assessment in relation to costs were disproportionately incurred, this shouldn't have been claimed, and whatever. There's no bar to that. But in terms of Part 36, which is what the webinar is about, if the claimant had made a Part 36 offer, we're seeing the case where £1 was offered, the costs are going to be assessed for 21 days after offer on the indemnity basis. And that can make a tremendous difference to the way assessment works. If you make an offer for damages and a separate offer for costs, it suggests what if the defendant accepts the offer and costs and not damages and continues to dispute the same. I think that's unlikely. Maybe it should be made afterwards, because the offer for costs is conditional upon the offer for damages being accepted. How would you explain to your client inspired guesswork without the client looking confused and puzzled at the word guesswork? I think that's one of the most difficult parts of our job, really, is that we've got to say, for instance, claimants dealing with offers where we haven't got a counter schedule. You've got to go through and say, these are the risks, these are the advantages. We can't offer you any certainty, but these are the matters. And it does involve guesswork. What are they going to argue? What's the expert going to say? What's going to come out in the joint experts report? all those issues involved. I think guesswork is a it's probably an unfortunate word, but it involves informed consideration of the possibilities, which is the most likely. If I were to offer 95% on liability in a claim worth, say, £5,000, or the judge would say not a reasonable offer reduction. Now, there are cases, Douglas, where they've said a reduction of 5% is okay. It's not nothing. You can't just say it's nothing. It's less than they would have done, and it is a substantial sum. When attempting to agree defendant indemnity costs paid by the claimant due to late acceptance of a Part 36 offer, is it wise to make a Part 36 offer on those costs used in Form 1024A? You can always make a Part 36 offer on costs. And it's difficult to get defendant to agree to pay the indemnity costs. You'd have to make an application. I've been involved on the periphery of one of these recently, and it wasn't successful, basically, because indemnity costs in those circumstances involve conduct out of the norm. Okay, that's all the questions I've got. I think I've got to them all. If I've missed any, as I said, do get in touch. And thank you very much for watching. As I've said, I suspect this won't be the last webinar ever on Part 36, but they've been fascinating questions. As I've said, I will deal with one or two issues that arise from that, in particular the one about solicitors' no-cost assessments, and probably be writing about it soon. Thank you very much for watching.